Well, I'm excited today because we have John Lauro on the show, and John's a longtime friend, wonderful guy, and one of the best criminal defense lawyers that we have. And I'm going to be talking to John today about a little case you may have heard about: United States of America versus Donald J. Trump. Welcome to the show, John.
Welcome, David. And it's an honor to be here with you, and you know how much I think of you. And simply put, you're the best. But I really appreciate being here.
So John, let me start off with something I always ask folks, and I'll ask you: how did you get involved in this case?
It's a little bit of a long and winding road, but I have a relationship with one of the lawyers that is close to President Trump, and he suggested that I get involved. Several weeks ago, I met with President Trump, and we had some discussions about coming on board, and then ultimately he hired me. I have to say, initially, there was a sense that the special counsel and the Justice Department would not move forward on this J6 indictment. So it came as a little bit of a surprise when it started to heat up and it looked like there actually would be an indictment.
And I know, at least in the Miami case, I should say the Fort Pierce case and some of his other cases, he's put together teams. Are you going to be part of a team, or is it just going to be you and Todd Blanche?
Definitely a team right now. The team is Todd and me. And as you know, Todd's an outstanding lawyer and a fearless defense lawyer. We're working as a co-counsel right now and dividing up responsibility. Todd is also working on what everybody calls the documents case in Florida.
Right.
I'm just working on the J6. Obviously, this is a very, very large and significant matter. It's going to take up a lot of time. I assume at some point there'll be other lawyers on board, but essentially right now, Todd and me are handling it.
So, John, whenever you get involved in a case as a criminal defense lawyer, you have to sort of decide if the case is right, if you have enough time, if the client's right. You're at a point in your career where you can take whatever case you want. Did you hesitate in taking this case? Was it a difficult decision, or when you heard about the case, you jumped right in?
I really didn't hesitate. I thought the issues would be so extremely interesting. I thought the challenges would be enormous, but David, this is the life we've chosen, right? And we enjoy these types of tough criminal cases, and I know you've been through so many difficult cases and successfully walk clients through. And I think there's a part of us that always believes that we can do it and we can get the client to the other side of freedom. So it's always a hard challenge. This case presents unique issues, though, as I think you know. First of all, anybody representing President Trump becomes a target, himself or herself. So the lawyers are now being targeted, both in social media, in the press, and more fundamentally by some interest groups that are seeking to file complaints or grievances against lawyers. So it's a very dangerous, it's a very insidious atmosphere right now. So it's not just taking on a client that is presents challenging issues. You're also kind of putting yourself at risk. And I know our mutual friend Alan Dershowitz has spoken about that and written about that. And Alan has been subjected to vicious attacks, unfair attacks. But as they said, the first thing that you need to do in the road to totalitarianism is kill all the lawyers. And that's kind of what's going on here.
So have you already experienced that in the brief time you've been in?
Vicious attacks. I get 100 phone calls in my office, most of which are ugly and terrible. People sort of emoting in a very nasty way. I get some very nice calls as well, but given the passion of the moment, it has really set people off, and there's a lot of anger, which is one of the reasons why I'm really disappointed that Department of Justice brought this case right now. It's in the middle of an election cycle. It's in the middle of a time when people are really, passions are high and emotions are high. And to bring a case like this is just really dividing our country even more unnecessarily. So I'm glad to be involved in the case, but I'm so sad that it was brought at this time.
When should it have been brought? If it, I mean, obviously you think it never should have been brought, but you think they should wait until after the election. Is that the idea?
Which they can do because there's no statute of limitations problem. There's no issue there. They could have even indicted and sealed the indictment. But what was so disappointing is that it was brought right in the middle of the election cycle. And it's creating enormous problems because you have a client who is not only a client in a criminal case, but also a political candidate that wants to speak out on these issues. And it presents a very difficult intersection between your role as a lawyer for a client and your role as a lawyer for a client who's a candidate for president. And I should add, the leading Republican candidate right now.
Yeah.
So it creates all kinds of issues that we've never seen before in a legal case.
But you know, he talks about the indictments, your client, as if they're helping him on the campaign trail. I don't know if that's rhetoric or if it's not true, but you know, he seems to think that the indictments have been helping him.
David, I'm not a politician, but
Yeah.
I believe they are, and they are invigorating him and his campaign. He feels that he's under attack, but he's representing the people that support him, and he's taking this on as a way of showing his leadership and his resilience. But there's no lack of fight in him at all. I was with him after the arraignment, and we came back in the car together, and he was upbeat and positive and moving ahead on some campaign issues. But you know, a lot of our clients are thrown into a fit of depression when they face something like this. But for President Trump, it's just the opposite.
Is he a difficult client, John? Because you know, we've seen in the press his tweets, his social media posts. He's gone after folks, including the prosecutor, and been pretty hard. Is that difficult to deal with as a lawyer?
It's a unique setting because normally what we tell clients, of course, is don't say anything, don't make any public comments. With President Trump, because of the campaign, and I would say because of his personality, it's impossible for him not to speak out on the issue. So it does present unique circumstances. My approach as a lawyer obviously is very different than his as a candidate, but he feels strongly that he needs to speak out. And he also, in particular, looks at this prosecution as a political prosecution. So as a result, I think in his mind, it's sort of fair game from a political perspective to make these comments.
It's got to be hard on you though, because he's got two hats to wear, you know, the political hat and the criminal defendant hat, and your interests, of course, are solely in representing him as a criminal defendant and as his lawyer. So when he makes comments like Jack Smith's deranged or things like this, you know, it gets brought up to the judge. It's got to make you uneasy a little bit because judges are, of course, going to react to that.
I have a responsibility, certainly as an officer of the court, to conduct the proceedings in a dignified manner, and I will do that at all times. To the extent that you know, I can make any appropriate suggestions to a client, I do.
Yeah.
But as we know, David, sometimes clients follow our suggestions, sometimes they don't. But I think also what's happening now, given the onslaught of these cases, is that judges and prosecutors kind of understand the dynamic in terms of there being, you know, sort of a campaign going on. And I think it's a little bit different than our standard case where we would pull out our hair out if a client commented on a prosecutor or a judge.
Right. It is interesting because the prosecutors put the social media post, one of them in a motion for a protective order, which To me, you can complain about his post if you want, but I'm not sure what it had to do with the protective order.
It didn't really have anything to do with the protective order, but what the government proposed was a protective order that would prevent the dissemination of any discovery material that the government turned over. So, for example, if the government turned over a memorandum that was exculpatory and that was indicative that President Trump had no criminal intent, the government basically wants to keep that secret and has said, we will not allow you to turn that over to the press. And we feel strongly that that's not the proper role of a protective order. And unfortunately, in my view, what the government did is they used one of his political tweets to suggest that that was a reason to keep all of this discovery material under wraps. We're dealing with that issue. In fact, we're dealing with it over the weekend. We hope that it gets resolved in some way. I think the judge is going to have to step in and resolve it. But you're right. The motion for protective order really doesn't have anything to do with the tweets. And by the way, some people in the press have characterized it as a gag order. It's really not a gag order. It's just a limitation on disclosure of discovery.
It is weird because we've seen these motions for protective orders in lots of white collar cases lately, and you and I are dealing with them in sort of the run of the mill case, and they're getting more expansive in every case. It makes no sense to me, these protective orders. I mean, they're really limiting how a defendant and his lawyer can defend the case in a lot of situations.
David, it's awful. I think as criminal defense lawyers, we have to fight back, and we have to really start looking at an organized way of responding to these. I mean, in this one order, they suggested that counsel would have the responsibility to look over the client's notes and make sure that certain things were not in the notes. I've never heard of such an intrusion in the attorney-client relationship, but unfortunately, the prosecutors are getting away with it, and judges are entering these orders. But I couldn't agree with you more. We need to fight back. These are terrible orders.
So let me ask you, because you did something today that is known as the full Ginsburg. You were on every news show this morning, which is tough to do. How did you do it? How did you get to each one?
I would never ordinarily do it, and I don't like to do it, honestly, because you're subjected to a lot of misinformation in the press when you do it, and after you do it, where your words are scrambled and jumbled and misinterpreted, and sometimes very flagrantly misinterpreted. But because of the fact that this is a indictment that implicates so many political issues and so many important constitutional issues, the consensus was that the president's lawyer had to speak out on these issues publicly. And in particular, because of the fact that it's been brought in the campaign cycle, it was important to advise the public about our position regarding some of these important legal issues. So for that reason, we decided to go, I guess they do call it the full Ginsburg. It alludes to Monica Lewinsky and back in the Bill Clinton days. It's not easy, and it's gotten harder because the press is so combative. It's not a matter of listening to a lawyer's points. It's about battling and getting competing narratives out. It's very different than when Mr. Ginsburg did it 20 years ago.
Well, it was really interesting to watch, and some of the media, a lot of them were debating with you. It was interesting, and they only have a limited amount of time. I thought the first interview you did with Caitlin Collins, she's obviously very tough and smart, and both of you were great. And a lot of the interviews today were great too, because it was a good back and forth.
I have to say, I enjoy the more combative interviews for that reason. And also, candidly, the combative issues or interviews sometimes raise issues that you haven't thought about, because we're in our own little bubble as defense lawyers, and we're drinking our defense Kool-Aid. And it's good to battle it out, particularly with people in the media who are obviously intelligent and smart. maybe not trained in the law, which is good because they're asking questions that maybe a juror would ask. So I don't mind it. It has its benefits. Let me say that.
So were you on set on for these interviews today, or only a couple of them, or how did
It's
it work?
like a roller coaster because
Yeah.
you literally go from studio to studio, and you do a number of these in a minivan, in isolation, where you're not next to a human being. You're just in either a room or a van all by yourself, and you're talking into a camera that doesn't have a person on the other side. So you're talking into like a dark image. So I don't know how it comes across, but it's a little bit awkward, a little bit difficult. But again, you're trying to make some of the defense points and really educating the public more broadly.
So, John, you've obviously been doing the press. Your co-counsel, Todd Blanche, who, by the way, I had on a few weeks ago, and I love Todd. He's great, but much different style, much more low key. Has not been in the media at all. I think my podcast was his only interview. He has been out of the media. So why the different approaches between you and him? Is that just a style thing, or is that something you were asked to do?
As you know, Todd is an outstanding lawyer, and it's been such an honor and pleasure to work with him. We complement each other, I think, on different things that we like to do and enjoy. I kind of like dealing with the press and the press issues. I think Todd enjoys other aspects of the trial work and litigation. So we're just dividing up the workload in a way that makes sense for us.
Good. Yeah, no, that makes sense. And you can just see it, the different styles, and it's good that you guys complement each other. I like dealing with the press too. And I think it's important to get out there for a client, especially obviously in a high profile case like this, because otherwise you just have sort of the talking heads out there who are making a narrative against your client. It's very difficult. You have to combat that.
I couldn't agree more, particularly in some of the high profile cases where your client absolutely wants you to deal with these issues, including the narrative of the issue. And I know, David, you just finished an outstanding case involving a political figure in Florida very successfully. And I'm sure he wanted you to speak with the press and get his message out more broadly.
It was interesting, obviously, a completely different scale on a 1,000 to 1. But, the local media in that case, in the Andrew Gillum case, would come to the court every day. And, I would speak to them at all the breaks, before trial, after trial, at the breaks, and try to explain to them what happened at the hearing and have an interaction, because I thought it was important to try to shape what was going out, not in a spin way, but so that it was accurate. Because I thought making sure the press reported accurately on the trial was important, not just for the client, but for the public to understand. We thought we were winning every day. So we didn't want, the media to say it in a negative light.
I couldn't agree more, once again. And I find sometimes the local media is a little bit more kind of attuned to trying to get to a right answer, whereas some of the cable networks are kind of pushing their own agenda, and it's motivated perhaps a little bit more in terms of an entertainment factor. But either way, I think lawyers in this modern age have to get their clients' position out in some way. Now, it's a risk because you're making statements, you're saying things that could reveal defense strategy, but I think you have to consider those risks, and in the appropriate case, absolutely make a presentation to the press and engage with the press.
I will say that the national media is interesting, right? Because obviously the hosts are very smart, but they have as their guests all of these very slanted former prosecutors. So, it bothers me that they don't have real criminal defense lawyers, at least to debate the former prosecutors who are taking the position that, they read the indictment and they say, there's no other verdict but guilty after reading this indictment. They literally say things like that.
It's very disturbing to me because, we're dying the will defense lawyers. If Hunter Biden called me tomorrow, I'd take that case in a heartbeat. No, it doesn't matter. we defend our clients, to the death professionally, obviously, but as hard as we can. But some of the legal pundits, they look at the case as, how can this end in conviction, as opposed to, wow, let's look at this critically from a defense standpoint. And unfortunately, these news media outlets, they love to say, oh, we have the former federal prosecutor from blah, 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 as if that gives you some kind of credentials to talk about criminal cases. But the reality is that true defense lawyers are underrepresented on these shows.
I mean, there are some, and I respect these guys a lot and get along with them. Some of them have never tried a criminal case,
or tried a defense case. They may have been a prosecutor their whole lives.
That's what I mean.
Yeah.
Some of them have never represented a criminal defendant. Some of them have never given a closing argument for an individual. So they only see the world in one way, and so it's unsurprising when there are three of them with a host talking about a case that they say things like, that's not a defense, or it doesn't matter, criminal intent doesn't matter because he did it. I mean, it's odd to hear those kinds of things come out of their mouth.
I'll give you a perfect example. Bill Barr was on, former attorney general, and he's going, advice of counsel, that's not a defense. First Amendment, that's not a defense. And I'm thinking to myself, dude, you haven't tried a criminal case in your life, okay? You don't know how to build a narrative, a defense narrative. All of these are issues you throw out in front of the jury. My gosh.
Well, the advice of counsel, and when I saw him on that interview say, well, we'll have to hear from Trump for the advice of counsel, so that's not going to be a defense. Just totally wrong. Advice of counsel can be raised without a defendant testifying. It happens all the time in white collar cases. We see it all the time. That was just a misstatement.
Yes. No, I know. And then today, one question was from one of the people that was one of the hosts said, Mike Pence said that President Trump, his suggestion of not counting electoral ballots would be a violation of the Constitution. Isn't that criminal? And I said, well, a technical violation or a violation of the Constitution doesn't automatically mean that there's a criminal offense. You still have the prosecution burden to prove beyond a reasonable doubt. Well, it comes out in the media, Lauro admits that there's a technical violation of the Constitution, but still says it's not criminal. And unfortunately, these words get twisted, but we as defense lawyers build a defense narrative from the ground up, and we really are our client's voice in the courtroom. And oftentimes our clients don't testify. So we have to take advantage of all of these issues. And certainly from President Trump's standpoint, the legal advice that he was getting is critical to his defense.
Of course. I wish every time a police officer violated the Fourth Amendment, it was a criminal, there was a crime committed. So let's talk about venue for a second, because there's been a lot of discussion about the DC venue and whether that's an appropriate venue. Are you going to be moving to change venue, John?
We are at the appropriate time. We need to do some work on, I think, some hard quantitative analysis of where people are in terms of thought process and what the venue looks like. Washington D.C. went 95% for Joe Biden, 5% for Donald Trump. The prosecutor, Jack Smith, made some, I think, unfortunate remarks in announcing the indictment and alluding to the violence that occurred on January 6th, even though President Trump was not charged with inciting violence. So we have some challenges in front of us regarding getting a fair and unbiased jury. So you can expect that we're going to try to move venue.
And does the political leanings of the jury, I mean, is that a determinative factor? Because I guess the opposite might be true in Fort Pierce, right? Trump got a majority of voters in Fort Pierce, I think. And so would there be an appropriate, should that case have been brought by the government down there if a majority of voters voted for Trump?
Fascinating question in many respects. I don't think political affiliation is the end all and be all. I think it's one factor, but I think you have to do some polling and get some social science and quantitative analysis in terms of how people are reacting to the indictment. I think that's going to be an important part of our motion. Fort Pierce I looked at the statistics, it seems to be fairly evenly divided politically, even though I think President Trump carried that area or that county in general. So I think the political piece is in play to some extent, but I think you're right. It's more of whether or not you're facing this sort of roadblock of bias, and whether the community in which you're trying the case has been affected in an emotional, passionate way, which certainly Washington D.C. was on January 6th compared to Fort Pierce, which really doesn't have that kind of emotional connection. But I will say this, of greater importance is the special prosecutors or special counsel's decision to bring that case in South Florida, I think is motivating them now to try to play a hurry up offense in DC and try to get to trial in 2 months. They're suggesting that they can try this case within the speedy trial clock, which is 70 days. Of course, that's absurd, but they're literally, they want to meet with us over the weekend to produce discovery. Have you ever heard of a prosecutor saying I'm available on Saturday and Sunday to talk about my case?
I wish they'd answer the phone during normal business hours in the normal case. Before we get to the speedy trial part, let me just stick with venue for 1 second, because you suggested West Virginia, and I'll push you a little on that, because a lot of people will view that as, well, they're just trying to get to a location where Trump carried the day. So why West Virginia, and why not? Shouldn't we find a place where it's 50-50?
Well, interestingly enough, northern West Virginia is a fairly split area of the state. Southern West Virginia tends to be more bedrock Republican, but we looked a little bit at the northern part of the state, which is in very close proximity to Washington D.C., and it is a very diverse, evenly divided area, which, at least from all our initial analysis, would make a good spot. I'm not wedded to West Virginia by any means, but I think we have to get out of sort of the Washington D.C. mindset, which includes some of the suburbs in Maryland and Northern Virginia. I went to school there. I know the area very well. It's it's a lovely place to live. But politically, it's a lot different than some other places around the country.
I worked there in DC after a clerkship, and worked at Williams and Connolly. I always try to think about what Edward Bennett Williams would be doing in a case like this. He famously said he don't talk to the press, but of course he represented the Washington Post, National Enquirer, all the different law firms, so he could talk behind the scenes.
Yes, there was a lovely biography years ago, The Man to See.
The best.
One of the best books about criminal defense, and obviously a hero to both of us. And a different era, though, certainly for a defense lawyer.
Very much so. By the way, DC, I mean, as you know, is typically considered very defense friendly in the normal case, and Fort Pierce is usually considered very government friendly.
Yes.
It's interesting that both sides have sort of think of them as in reverse in this case.
Yes, and again, I think that's part of the political passion, candidly.
Right.
And we used to think of conservative jurors as being very pro-government or pro-police. And now that may reverse the script, for our cases, because it may very well be that we want to take a look at more conservative voters who might be a bit more cynical about government and government agencies like the FBI or the IRS. So from a white collar perspective, I think we may have to look at these issues with a new pair of eyes.
I tried a case recently where our focus groups told us we wanted older conservative men on the jury, which never would have been the case in the older, even 5-10 years ago.
I agree.
Yeah, it's wild. So let me ask you another issue, the recusal issue, John. So, obviously your client has already called for the recusal of the judge. You haven't filed a motion yet. Is that coming? Is a motion coming on recusal?
I need to take a hard look at this issue from a legal perspective, and want to make sure that it is correctly and exhaustively analyzed. So We've made no final decision on that issue. It has to be really looked at with a fine-tooth comb. It raises a lot of issues. I think the president's response was more from, you know, a layman's political sense of can I get a fair trial in front of a judge who, let's say, was appointed by a Democratic president. But we haven't made a final decision on that issue at all, and that's something that requires a great deal of legal research and assessment.
Right. It is interesting, again, just to compare the documents case, right? Because in that case, you have a Trump appointed judge. And so it is dangerous, I think, to start getting into, well, who appointed this judge? And therefore, that judge can only be fair to one side or the other. I do think the bar will get a little nervous with those kinds of arguments, right?
And the judge in the documents case has been criticized by kind of, you know, the left side
Sure.
of the spectrum, and viciously criticized. So I think as lawyers, we have to be very careful of those issues and handle them with the utmost delicacy and the utmost appropriateness.
I know Judge Chutkan has already denied a motion to give you a few extra days and is making you guys work over the weekend. I will say, she was on a panel with my partner, Margot Moss, recently, and I got to meet her. She's smart and lovely. So I hope you have a good experience with her.
I'm hoping as well. And as you know, David, we always, you know, we pull our hair out when we have these deadlines. The government filed something on a Friday, and they wanted an immediate response Friday evening, but we're getting there.
You know, I don't ask for much of judges these days because I typically expect them to rule against the defense. The only thing that I really care about is, like, can you work with my calendar? That's it. And so the judges that aren't willing to do that, it really bothers me. Just a couple extra days. I'm not sure what the problem with a couple extra days was.
Several years ago, I had a case in South Carolina, very, very lovely gentleman who since passed away, Judge Saul Blott, and really an institution in South Carolina. When we would pull out his calendar, he would make sure that, you know, we had enough time around Mother's Day or Father's Day. He would ask, you know, does anybody have any family commitments? Are there birthdays? It was such a different experience than what we're used to.
Yeah, no, that's how it should be. One issue that the left and the right seems to agree on, and I've written about this, and one of the first things you said is there needs to be cameras in the courtroom. It kills me that we're relying on a sketch artist and we're relying on somebody to summarize how they looked. Or why can't we get cameras in the courtroom?
I have no idea, and it works in Florida for us. There's no, you know, no gamesmanship. And what I think is really unfortunate is in the high profile cases, the case itself is being explained through the lenses of people that, you know, maybe aren't particularly trained in the law, but they're really also giving way to their own biases and their own analyses, as opposed to letting people just see for themselves what's going on. And I think it has such an important educational value to allow ordinary citizens to see how the legal system works, because right now, a lot of people have no idea what goes on in a trial.
Well, it's interesting that you mentioned Florida, in a case that you and I both have some relation to, the Charlie Adelson case. That will be televised. The first two trials of co-defendants were televised, and there were no issues. That's as high profile as you get. And there was not an issue about the trial or the lawyers playing up or anything like that.
It was seamless. I was at both trials. Obviously, I'll be at the next one. There were absolutely no problems whatsoever. And this concept that lawyers are going to ham it up for the camera is just ludicrous, because if you do that, you're going to lose credibility in front of the jury. You're going to hurt your client. And I didn't see any of that. The other thing that I noticed, and you probably see it as well, is over time, you even forget the cameras are there.
Right.
And you just try your case and you don't even think about the camera.
Let me ask you, you say you'll be at the next trial, not to talk about that case, but how do you keep up your practice with this case? I mean, you're going to be working 24/7 when you do have to go to that trial, when your client testifies at that case. I mean, are you going to be able to carve out the time, or are you going to have other people help you out?
No, I'll definitely be there for Wendy without any doubt whatsoever. So no, I'll be there. As you know, in a small firm, we always have challenges and always have a lot of demands on our time. Again, this is the life we've chosen, right?
Yeah.
We could have gone a different route, David, being a big firm and have, all the other characteristics of that kind of practice, but we made a decision to go in this direction, which I would never change, obviously, because of the love that both of us have for trial work and representing individual clients.
So you mentioned speedy trial. You said the government wants to get this case tried by the end of the year, speedy trial clock. I mean, to me, regardless of what you think of the case, it's crazy to think that this case should be tried that quickly. I mean, when do you think the case should be tried, and how long do you need to get ready for it?
In large white collar cases of this magnitude, we're looking at probably between 300 and 400 potential witnesses, including an enormity of evidence, of pulled evidence. It went through a congressional hearing January 6th, a grand jury proceeding. We're looking at terabytes of electronic evidence. In a case like this, I've never seen a white collar case go to trial in less than 2 years of this magnitude. And what people don't realize is the lawyers have to go through all the evidence. You don't just show up at trial. Trial work is hard work because of the preparation. You don't just show up and start cross-examining witnesses. You have to know everything about the witness, everything they said, read all the documents, and it's an enormous undertaking. The government has had 3.5 years to investigate this case. They've had over 60 lawyers and investigators working on it, and they want to put us on trial in 60 days. It's just absurd.
It really is absurd. One of my favorite all-time shows, I don't know if you've ever seen it, was The Practice, about a criminal. It was a great show. You kind of look like Bobby Donnell, by the way. But the funny thing about that show is they would always have, somebody would be charged with murder and they'd be in trial within 2 weeks. That was,
they get it resolved in 45 minutes.
yeah. I mean, the show was great, but getting to trial quickly is just, especially in a case that's so complex. I mean, it's hard to imagine that this would get tried before the election. I guess, even assuming you're ready, should it be tried before the election?
The problem with trying it before the election, first of all, given the magnitude of the evidence that we have to look through, there's just no way that a human being, one lawyer, two lawyers, three lawyers, could get ready before November. But let's assume we start trial in July. We're literally going to have a presidential candidate sitting at trial for weeks on end, because in the federal system, you have to be present during trial as a defendant. You don't get to walk away. So I just don't see it as being a meaningful, approach. And plus, the government's obligation is to do justice in a case, not to just win a case. And if the defense is saying we need more time to get ready, then the government should recognize that the defendant's Sixth Amendment rights to counsel and rights to due process outweigh any prosecutorial zeal to bring a defendant to trial before an election.
A couple of the potential witnesses is one of the Republican rivals, his former vice president, Pence, who is out there talking today that, he says he's not going to be a witness. I don't think he realizes he doesn't have that choice.
David, I've already read his book twice. I'm starting to prepare my cross-examination of him. I'm trying to get into his head, frankly. I'm trying to understand his personality, who he is, exactly what we do as defense lawyers. I'm trying to be Mike Pence in a sense, to understand where he's coming from. And he's going to be a central witness in the case. I don't see how he's not a witness, but I have to make him a defense witness. I can't allow him to be a prosecution witness.
Well, I assume if the government doesn't call him, you'll call him.
100%.
Right. Does he, it doesn't sound like he realizes that you can subpoena him and he'll have to be there and have to testify.
I don't see how they can do an obstruction case involving Mike Pence without calling Mike Pence.
Well, that's a good point. Although we've seen many cases where they try to avoid these witnesses that are sort of wishy-washy for them, and it sounds like he's not willing to come out and say what the government needs him to say.
I agree. He really hedges, because I actually commented on that today. He's never said that he thought the interaction with President Trump was criminal, or that he was pushing back in terms of any potential criminal violation. He certainly disagreed with the president's counsel, John Eastman, and he disagreed with some of the options that were presented in terms of their constitutionality, but he's never raised any concept that he thought these discussions were criminal or fraught with criminal liability.
Let me ask you just a couple more topics, because I know you're so busy, and again, thank you for doing this. The First Amendment defense that you've raised, a couple things about that. One, was it a tough decision to put that out there? Because one of the only things we have going for us as criminal defense lawyers is this element of surprise. Now everybody knows the defense and is sort of digging into it really hard, and you hear, you know, the talking heads trying to dismantle this First Amendment defense. Was it a tough choice to put that out there, or did you want to educate everybody?
A couple of things. It certainly was anticipated by the prosecution. In fact, they even allude to it in their indictment, that he has a First Amendment right. So we knew it would be out there. Candidly, we had some pre-indictment discussions with the prosecution where we discussed the merits of not going forward.
So they know about it.
They knew about it.
Right. And you know, it's interesting because the former prosecutors who know better, who are out there, are saying, listen, speech can be criminal, like if you agree to rob a bank. Well, but obviously very different. And that analogy that they're using, the agreeing to rob the bank analogy is so easily debunked. What do you, have you responded to that publicly yet? Or
I have. It drives me crazy, as it drives you crazy, because they use examples of like lying to the SEC or lying on a prospectus, you know, that's somehow criminal. Of course it is, but that doesn't involve political speech and policy. What we're talking about here is petitioning political leadership for either a redress of grievances or taking a political position. Political speech is the most protected speech under the Constitution, and it's a strict scrutiny analysis. Commercial speech doesn't receive that same degree of protection. So the talking heads, candidly, on this one, don't know what they're talking about.
are you going to file a motion to dismiss? I assume yes. And I think on that particular issue, you're entitled to an interlocutory appeal all the way up.
I'm looking at that. And in fact, Professor Dershowitz has raised that in some of his commentary, and I listened to him carefully, as you do as well. So I am looking at that issue.
Yeah, it will be interesting because that alone, that motion, and if you can take it up, I mean, that appeal, it could go all the way to the Supreme Court before trial. So if that issue does get litigated, the chances of this case going to trial before that goes all the way up is very slim.
All of these issues are ripe for Supreme Court analysis. The application of the First Amendment, the question of whether or not President Trump has immunity since they're indicting him for acts that he took as president, the question of the Klein conspiracy, whether or not it's applicable in a political case such as this, the interpretation of the obstruction statute, 18 U.S.C. 1512, and whether or not it's properly applicable, and the question of corrupt intent. This is like a law seminar on white collar issues. This one case.
You know, the obstruction, just real quick, the obstruction statute, that statute, another section of it was litigated in the Arthur Anderson case. Everybody back then talked about how bad Arthur Anderson was, that they should go down. It ruined the company, and then the Supreme Court 9-0 reversed the conviction. Some of the talking heads that are out there were prosecutors in that case.
I know one in particular.
I do too, and it bothers me because he still believes that prosecution was righteous, even though 9-0 it got it got thrown away.
And look what they did to the former governor of Virginia, that they prosecuted him on this wackadoodle theory, and it got reversed 9-0. And then Senator Menendez in New Jersey was prosecuted in a case that went nowhere. So you and I are rightly suspicious of when prosecutors try to expand the scope of criminal law in a high-profile case and really try to fit a high-profile case into a statute. And they often think they can do that, and then they get whacked down by the Supreme Court or another court. But in the meantime, you've ruined a person's life, you ruined a company, and then it's terribly devastating. And then, of course, you go and you get hired by a big firm and you become a big partner at some big firm. But the reality is, look at the destruction in the wake.
It's very difficult. And one of the things you said up front about, life we chose, I think part of us have some wiring that's messed up for us doing these kinds of cases, John. But let me ask one other issue before because I know we're limited on time, is it's going to be hard to keep your client off the stand in this case. And I know a bunch of people have asked you whether he'll testify. And of course, you can't say whether he'll testify or not. But people expect politicians to testify. One of the very difficult decisions we made in the Andrew Gillum case was not to call him because the government completely failed. And let me tell you, there's no more gifted speaker than Andrew Gillum. And he could have made mincemeat of the prosecutors. I believe he would have crushed them, but we didn't call him. He listened to us. Is Trump going to listen to you if you tell him not to testify?
I'm not sure I can answer that right now,
Yeah.
but I will say this, that it's an important tactical issue. But my most favorite cases is to develop the defense narrative on cross-examination and pound away at cross on the government's witnesses, and then not put on any case at all and go straight to closing argument and keep it as neat and clean as possible and not put a client on the witness stand. I hate when clients testify. I just hate it because you've now lost control over the narrative, and jurors can pick up on the slightest, smallest things to find a conviction. And also, in many instances, you want to preserve legal issues so that the appellate courts don't look at this as a referendum on a client's credibility as opposed to focusing on the legal issues. So we have to take all of that into account. But my most favorite case is never putting on any evidence and going right to closing argument and saying why the government hasn't proved this case.
So great. So great. Well, John Lauro, thank you so much for doing this. I know how busy you are, how much pressure you're under, and how difficult a time this is. So thank you.
No, thank you, David. Always good to see you. I can't wait to see you in person as well. And God bless.